Good afternoon, everyone. We welcome you to the webinar organized by the Insolvency and Valuation Standards Board on the topic. Any problem? Actually, it was thought that there are lots of responsibilities which are on the committee of creditors, and there are challenges which are being faced by insolvency professionals due to the duties or responsibilities that are not being taken care the way they should be, or there is some understanding gap between the CoC as well as IP. So it was not fit to organize a webinar on this topic. We have with us our chairman, C. Gyanchand Mishra sir, of the Insolvency and Valuation Standard Board. We have Vice Chairman Sir C. Rajesh Sharma Sir. Then we have two speakers for today, C. Abhilash Lal Sir, who is the insolvency professional. We have Ms. Anju Agarwal Madam, who is also an insolvency professional. And moderator of the day, we have Rashmi Shaucharya Madam. She is also an insolvency professional. We welcome all of you to this. With this, I would request C. Gyanchand Mishra Sir to give his welcome address.
Thank you very much, Sarika Madam, Respected Secretary of the Committee, very dynamic Vice Chairman of the Committee, C. Rajesh Sharma Sir, Honorable Central Council Member, two distinguished speakers, Abhilash Sir, and everything, Anju Madam, and Rashmi Shaucharya Madam, who is moderating today's program. Friends, this program being organized today, truly speaking, is very important, and it's too late also, because such programs should be organized from time to time. As said by Sarika Madam, that responsibility to the CoC vis-a-vis to the responsibility of the insolvency professional. Rather, I will say power of the CoC vis-a-vis to the responsibility of the insolvency professional. Because indeed, this is very important subject to understand what is the equilibrium point where the power of the CoC is to be exercised to the tune of the compliances of the insolvency professionals. On the one hand, if we see the insolvency professionals always think they are being overpowered in terms of the compliances. However, the CoC lot of time thinks that the insolvency professional, who is certainly one of the key element and important stakeholder of the entire insolvency process, is not ready to perform to the expectation of the CoC. However, this is very important to understand what are the limitations the insolvency professionals have with them. However, what are the challenges that the CoC is facing? Hence, to mitigate the entire ecosystem and intertwine the balance in between the two is the major aspect that we should discuss today. And I think that none other than these two wonderful speakers and wonderful moderator, because we have heard all the three so many times. They are very good in their segments, and we will certainly get benefit of the same. And I'm sure about it that this important webinar of today is not only going to emphasize on the powers of the CoC and responsibilities of the insolvency, but it will certainly throw the light where these two can be equated, where the insolvency professionals could also get a sigh of relief of working. Because as of now, the professionals are not very happy in the industry. So will not take much time, as Madam told, that about 1,000 of the professionals have joined us virtually. So I welcome you all from core of my heart on behalf of the board. One request that I would like to put before all the stakeholders: kindly do come forward for various activities of the board. like speaker, like moderator, like writer. We are going for the evaluation standards very soon. Some compliance file is pending at president's office. We are expecting that the same shall be done sooner. And after this, we shall be able to give one newer way, newer version of the valuation to the country and to the valuation professionals. So once again, welcome you all and happy learning. Thank you very much.
Thank you so much, sir. Now I would request here Rajesh Sharma, sir, to give his remarks.
Just I will not take more than a minute. Our honorable council member and chairman of the committee, Jan Mishra sir, has already explained what is the expectation. And as always, Sarika, who is secretary, our respected secretary for this committee, who have been always available to all of you. One thing which comes to my mind, I was part of some discussions when this law was getting formed. So once I met a few of the members of the standing committee, then there was a meeting in JTG's chamber. There also I was available. But the purpose of the law is not fully satisfied as I think it was being discussed that time. So, and whenever you speak to the stakeholders, the CoC says the problem is on the other side. Members of tribunal say the problem is on the other side. The IP say problem is on the other side. So we always keep the board rotating. So here you all are part of, I say you all are part of the committee, and you all make this committee, you all make this insolvency board, and you all need to ensure that we need to put ourselves in shoes of them also and ensure that resolution comes timely and efficiently, which was the main motto and main concern of the lawmakers at that time. Because a lot of problems are there. If I speak, it will be long. I congratulate Abhilash Lal sir and Anju ma'am and Preeti ma'am, all of them, for delivering to our members and giving their time to our fellow professionals. And I welcome each and every participant who is listening today. Thank you very much. Thank you.
Thank you so much, sir. Without taking much of the time, I will now hand over the session to Rashmi Shacharya ma'am. Ma'am, over to you.
Thank you, Sarika ma'am. Thank you, Durgesh sir, Rajesh ji, and the entire IUSB board for giving us this opportunity to discuss on the much needed issue, that is, the challenges faced by the resolution professionals with respect to the CoC meeting members and the compliances that he needs to make before the with the IBBI and the triple IP, ICR, or the IPE with which he is registered. So I would like to introduce the speakers first. We have with us CAIP Abhilash Lal ji. He is the insolvency resolution professional who has been appointed for the revival of the airline Go First. He had done MBA from IIM Bangalore and BE in MEC. He has over 35 years of experience in financial services, consulting, private equity, and industry. He has handled various assignments under IBC and also has experience in real estate, education, healthcare, strategy. He has worked across various functions and roles in corporate banking, including stress assets, institutional and private banking. So we can imagine him that he will be giving his views from the banker side also and from the insolvency professional view also. He can take up both the sides. I would like to welcome you, sir, to this discussion. And I'll also like to introduce IP Anju Agarwal ji. She's an accomplished professional entrepreneur with a robust background in strategic consulting, specializing in restructuring and a broad spectrum of financial services. Over 24-year career, she consistently delivered impactful solutions across sectors such as taxation, financial services, and legal compliances. So with Anju ma'am, we have, a strong woman who is there as an RP. So we can have, literally a discussion like what an RP feels and what should be the commercial wisdom of CoC. We can have a discussion, and we know that recently, there has been so lot of litigations also with respect to the CoC, commercial wisdom of CoC. CoC decisions are often challenged in tribunals, and the IPs are the ones who who is under the scrutiny, under the lens of the IBBI. So many times, we all know that as the company is admitted into CIP, the NCLT appoints a IRP, and the same is being confirmed by the committee of creditors. And many times, these committee of creditors comprises of the financial creditors or the operational creditors, and they always, because they need to bear the CRP expenses, they always need to, minimize the cost. They always want to, influence the decisions of the RP. So all these leads to, a very difficult kind of situation for the resolution professional, because he is governed by the IBBI. He has IBC code, and he is regulated by the authority as our IBBI. So all these, I think the speakers can, throw much light on the subject. And with this, I would like to invite Abhilash Lalji to give his view.
Thank you so much, everyone at the Insolvency Standards Board, Rashmiji and Anjuji. Welcome and good afternoon to all the participants. Pleasure here to be talking about this. Just two caveats before I continue. One is a lot of these are personal opinions garnered over the past experience that we have had. So please don't take it otherwise. I mean, and I request participants also to take it in the right spirit. What we are suggesting is issues that are faced from a solution orientation. Let us see how we can go about resolving these. If we point out, and maybe I'm speaking for Anjuji also, in case we do point out, some experiences that we have had where things have clashed with each other, it is not from the point of view of apportioning blame, but rather of saying, how these things can be avoided. And the second was just a small correction. I know I am in August company, but unfortunately, I'm not a CA. I am a mechanical engineer and an MBA, right? So thank you so much. And before I start, I would request that you hold more such sessions. We are talking about balance between RP and CoC. Let's see if we can get some sessions on RP versus judiciary, RP versus stakeholders, RP versus others also, right? Because very frankly, I think the role of RP would put most tightrope walkers to shame. It's like, walking across. I remember somebody walked on a tightrope across the World Trade Centers from one to the other. And I think he understood a little bit of what the RP's role can be like. Because unfortunately, the way things stand now, the IBC, which is a very well thought out piece of legislation, at the moment, it seems to control, condition, and regulate only the IPs. And I think it is time, when we start looking for balances between the various stakeholders, that we start looking at how others can be accountable. And I'm using the word in a very broad sense, because I think we all need a sense of responsibility to see how we can achieve the targeted objectives together. The CoC is an extremely important role. In fact, if you look at the very core of the IBC, the reason why financial creditors are chosen to be in the CoC is because they are supposed to possess what the IBC and the BLRC called commercial wisdom. Now, commercial wisdom stems from several parts. The key thing is, as opposed to an operational creditor, a financial creditor, before they give out any funds, will do a thorough check. They will look at least 3 years of financials, and this is the banker in me speaking. At least 3 years of financials. They will do a complete spread. They would look at all kind of operating financial ratios. They would look at how profitable the company is. They will look at the business model. They will look at the competition, the market outside. They will look at the competitive advantage that this particular company can employ. And before getting into the quality of management, the quality of product, etc. And this ability to understand the sector, understand the company, understand the product is what distinguishes a financial creditor from a simple supplier of, let's say, photocopier paper or even raw material. The key thing, therefore, is that the COC needs a better realization, a better understanding of what is exactly is expected of them. The COC members come to the table with a very good understanding of what the business environment is like, and therefore a more practical approach to resolving the insolvency, of making sure that the company continues on the path to resolution rather than simply following the process. And that, I think, is something that we need to stress upon all members of the COC. They are not here to ensure that it is only the regulatory uh, processes being followed. They are important, but frankly, that is more important from the RP's perspective. It is the RPs look out to ensure that the process is conducted in a particular manner. And in fact, I think our lawmakers have done a fabulous thing by saying the judiciary should not involve itself into commercial matters. That is left to the commercial wisdom of COC, who will take appropriate decisions. And the judiciary will only ensure that the process is carried out in the right manner, protecting all the stakeholders as is envisaged. This particular thing, I think, needs to be brought out far more starkly than it is happening now. And unfortunately, it is the lack of something here on the commercial wisdom which is causing a lot of these issues here. See, today, a very simple thing, I'll tell you. And Anjuji, please feel free to step in, because I think both of us together will be able to drive home the point more easily. For starters, at least in my experience, I have rarely found the decision makers present in the COC. It is usually just a representative who has representative authority who will come to join the COC meeting. They normally prefer to just note down what is happening in the meetings, go back to their office, prepare a note on what has happened and put it up to what they call the competent authorities. Right now, I'm not saying there is anything wrong with this, but just take a look at how it impacts the decision-making process and how the RP is usually left holding everything during the COC meeting. There is no guidance. And I'm telling you that guidance can be brought out in plenty, given that the financial creditors have been associated with the corporate debtor for quite a period of time. The RP has been there, what, 1 month, 2 months, even 5 months sector. But the financial creditor has been associated not just with the company, but with the entire sector for a very long time. And therefore, they will be able to bring in, a lot more guidance, which at the moment is not there too. I mean, I'll take an example. Let's say you're talking about something in the steel industry. If you're handling a corporate debtor, which is handling a particular steel product, as an RP, I may or may not know about it. I mean, giving a personal example, I have handled a case in hospitality, one in healthcare, one in airline, one in real estate, one in power, thermal power. And the role of the RP is challenging, which is one of the things I love. I mean, where else can I be CEO of so many different companies? But you have to remember that to make somebody the CEO of a steel industry, any want ad will first say, should have a minimum 15 years of experience or relevant experience or whatever. Here we are talking about an RP, whose forte lies elsewhere, but he is asked to come in and run the company. So to guide the RP better, I think the first thing the CoC needs to do is to understand their role. It is not just to approve or to delay or to whatever, but also to help guide the RP in how the company should be handled, etc. There are several other things, but rather than make it a monologue, I would request if Anjuji would like to step in here.
Sure. Thank you, Abhilashji. Thank you, Rashmi, and thank you to the Insolvency and Valuations Committee of ICAI. A very good afternoon to all the panelists and the board and the participants who are right now listening to us. So to start with, I think I will start from two things. One, that I think in their opening remarks, Rajesh also said that RPs are very powerful. And they have been given a lot of responsibilities and certain kind of rights, or I would say powers, to facilitate the whole process. My take on that would be, to start with, is that RPs actually are not powerful, in the sense like they are the facilitators, and actually all the powers rest with the CoC. So we are, court appointed officers who are actually kind of working to achieve a result for CoC. So we are merely, I would, in my personal opinion, I would not take this as a power or an authority. In fact, for me, it's like loads and tons of responsibility which an RP comes in a CIRP to actually achieve some goals and results for the CoC and other stakeholders if the valuation is good of the asset or the company. So, and as Abhilashji, in towards the end of his talk, he's talked about, then we actually infer power from CoC. So all the powers are with the CoC, and they only facilitate us to, kind of implement the whole code per se, and to be very specific, the whole procedural aspect of the code. So this is the first thing. So I am very mindful when I'm into a CIRP or as IRP or RP, that I'm here the most independent person who is there to facilitate all these stakeholders. Second aspect which was talked about is the conflict between the RP and CoC. So again, actually my experience has been little different. In fact, as individually, I have handled about 6-7 cases. And in totality, as my IP, we have almost handled now 40-50 cases, and ranging like whole sorts of out of the 12-13 big cases to all the smaller cases, all kinds of things. But what I saw in my experience, we never had been conflicted with the CoC actually. So we had been always like very cordial and very facilitating role, as I said, with the CoC. In fact, in my experience, most of the CoC members within themselves had been conflicting interests because they have different vested interests, and they had been more there have been more conflicts, or I would say arguments or problems among us, the CoC members, rather than the RP and CoC per se. And here the problem comes when we talk about the commercial wisdom of the CoC. So definitely the code talks about the commercial wisdom of the CoC. No, in fact, judiciary up till the Supreme Court is ready to touch upon this aspect of commercial wisdom of the CoC, and they really want to leave it with the CoC. But the problem is when there are two powers actually, and it can be 3, 4, depending on how the CoC's voting percentage and how these different financial types of financial creditors are kind of in the power game. So how then you decide, or even any of the courts decide, like what is happening amongst these CoC members who are actually all having their own commercial wisdom. So the problem actually starts sprouting from there, in my personal experience. So we then, in that sense, we all say, and the court says, that the CoC should look after. And this, I'm only talking about these financial creditors who are sitting in the CoC. I'm not even going towards the operational creditors or any other, stakeholders. If we, kind of bring in that aspect or angle to the problems, then obviously you can see the, magnificence of that problem. I'm not even talking about that, because otherwise, like, CoC members are supposed to take care of actually all the stakeholders. This includes like governmental departments, this includes the operational creditors, this includes the workmen and employees aspect of it, and then of course the shareholders of the company, if at all. But if they themselves are not, kind of having a unity or a consensus on decisions, then obviously it becomes a very big problem. So then who is more commercially wise among us, these members, is actually even more problematic. So I think on this particular aspect, I would like to say this only. Yeah.
And matlab that I would like to interrupt. Like all
Yeah.
these problems, as you say, matlab if there are CoC is not on consensus on some particular thing, then
Yeah.
this will create a problem for the RP, na, because he won't be
Course.
able to decide,
Yeah. Yeah.
and that will he will not be able to comply things which he needs to do.
Exactly. So actually, in these kind of situations, RPs are actually pulled apart, like in two different poles. So I'll give you an example of that, like specifically in the cases where the cases of real estate and there are home buyers. So that if, and in most of the real estate cases, home buyers actually more than 35 or 40% of the voting share. So that means they are in certain, control over the, because until if they, I'm so sorry, until they kind of agree to any of the resolutions, no resolutions can be passed. And these are the people. So if there are institutional financial creditors in that same CoC, and there are home buyers, so uh, they're both idea of running a CIRP is very different. Home buyers need their homes to be constructed, and the financial creditors want maximum recovery on their money which they had lent to the corporate debtor. And these two are actually conflicted, because any revenue if the company is having, or any money if the company is already having, or any liquid assets, home buyers wants that the whole money should be used for the construction of the homes. But CoC members, like the financial creditors, would want that this money should not be used, and later on, whenever the implementation of the plan is happening, they should actually get a part of it. So so the interest of both the financial creditors are very different, and if they both are into certain percentage of the voting share, then obviously an RP keeps. So in this case, which I'm particularly talking about, like 50-51% are the home buyers and rest are the institutional financial lenders. And in fact, so much so that the home buyers even would ask me that how have you kind of taken the interest of the institutional lender, how have not kind of reduced their claim up to what they have third party collaterals. I said, this is something not my problem. Like, if they have any third party collaterals, or if they have any other resources to take back their loan, that is not all their liabilities, or they are coexisting, and they can definitely file for the whole amount, until obviously something has been resolved, something has been, they have been receiving it. And that's not the case. And so so they were wanting, if at all I could reduce the claim of the banks, they would have in the absolute majority. So this keeps happening in another one of our cases. There are, so one is the institutional bank and one is the ARC. Now you can again imagine, like, the PSU banks, how they operate and how an ARC would operate, right? Then again, and they're almost like 40-50% each. Right. So the problems, in my experience, like, is more among us, the CoC members, rather than RP and CoC. But of course, like, we get the burnt. we get the brunt of the of IBBI if something is not happening. So if the case is being dragged, so this case which I'm talking about, where is this ARC and is a bank. So we have had so many show causes that why you are not getting to resolve it. And you won't believe, like, we started with something like 100 crores, and the resolution plan now have reached to 275 crores. And still, they are fighting among us, themselves, and the plan is not getting, approved, one single plan. And the burnt is coming all together to the to RP, because all these stakeholders, all the regulators are coming after us, like, why you have not been able to resolve this. So these are the problems, like, we see day in and day out. Yeah.
Yeah, if I may just step in, I think Anjuji has put the nub, the finger on the right knob. It is never directly a conflict between the RP and the entire CoC. If they were, I hope the whole CoC were united. The issues that we usually end up facing is because of differences within CoC members themselves, which can be as for various reasons, as Anjuji has pointed out. And I think that if the RP is able to carry the CoC members with them, and this is where, again, a bit of tightrope watching, a bit of explanation, a bit of persuasive powers. If you can get, as an RP, the CoC to completely agree with you, I think you will definitely have, I won't say agree with you, I'll say to go with you will definitely have a successful resolution. And I think we have seen cases that whenever an approved plan goes to the, adjudicating authority with 100% CoC approval, I have rarely seen a judge question the plan. They say, all right, accepted by how much? Oh, 100%. Oh, good. And then they will go through, the formalities. Has the Form H been done? Have all the stakeholders been looked after, etc., etc. And then you get the approval. It is only where they see dissension among CoC members themselves that, the judiciary will want to get into it and look at it. So I think it's important that, to handle the intra-CoC issues rather than inter. And I'm on the second part, as Anjuji mentioned, I'm reminded of Spider-Man's uncle, who said, with great power comes great responsibility. The RPs have great responsibility, no doubt. I don't know where the power is, certainly not the powerful stuff, right? So that's my two bits here. All yours, Rashmiji.
So moving ahead, matlab, like we have discussed this, matlab, okay, there is no concessioners. So what is the solution then?
Sorry, solution for?
Solution for the RP, matlab, if there is
Yeah.
no consensus, then the things will get
Yes.
delayed and delayed, like
Yes.
what is happening in
Yes.
Anju's case. So
Yeah.
how to matlab, regulate? If it is the CoC needs to come into consensus, otherwise it will end up into liquidation.
Yes, and I think it is a tough thing to answer. I wish there was a
An answer
definite
for it.
solution that we could provide. I mean, if I had one, I would have definitely patented it by now. Right?
Yeah.
But I think what the RP can do is, as I said before, try to cajole the CoC into accepting what is regulatorily the correct way forward. Right? Because let's be under no misconception. Our first priority is to make sure that we are regulatorily compliant. Then, secondly, try to get as best a commercial result as we can. So, just try and drive to them that make sure that you are regulatorily compliant. And after that, it's a question of trying to drive the CoC members to come together. I will illustrate this with an example if you will allow me a couple of minutes. I was the RP for a company where the best resolution plan was still below the liquidation value. And now, in the interest of resolution, CoCs do have to consider resolution plans below liquidation value. I was driving at 100% result for the reason I've already mentioned. The issue was that if And we were talking about 14 members in the CoC. And I went to each of their offices, met all of them individually. I figured out how many of them were on the side of voting yes and how many were the fence sitters. And I facilitated, one-on-one, one-on-two, one-on-three meetings with all of them. The whole issue was that if there was even one dissenter, the dissenter would actually get a higher percentage of the resolution value. I mean, given that it was below liquidation value and the dissenting FC is entitled to at least liquidation value, they would all end up. So that was one issue. And then what would happen? We don't realize. See, all the people who are coming to vote have taken internal approvals. So let's say the value was 100, the resolution plan was at 80. So they have all taken internal approvals to vote yes if they are going to get 80% of their liquidation value. Even if one person gets 100%, everyone else comes down to below 80%, which means their yes is not, I mean, they're not able to cast even a yes. So this becomes such a big issue. But I had a chat with all of them, and while, on face they all agreed, there is still that undercurrent of, mistrust, if I may call it that. I actually had the voting 4 times. You know what I did? I first sat them down and I said, I am not recording this. Please, I want all of you to come on camera just now to each other, to all your colleagues, and say yes. Secondly, do write it on a piece of paper also. And then thirdly, I said, I'm switching on the cameras now for for convenience at the NCLT. Please, I want you to repeat yes, yes, yes. They all repeated it, and then I said, we are adjourning now. I have opened the e-voting facility just now. Please vote it, and we will end this once we have a satisfactory vote from everyone. But all this, all I was doing was, engendering some kind of trust from amongst themselves. And we obviously, there was a lot of discussion involved, what is in it for you, what is not in it for you, how this will improve, how what will not improve. Thankfully, the SRA was a very well-known entity in its right, and they had kind of indicated that they would be happy to continue with the current lenders. So the lenders do have this prospect of, retaining the assets and, improving the asset quality at the same time. But that, I think, is the only way forward. The second thing is, of course, as I mentioned earlier, for CoC members to have a better understanding of what their roles and responsibilities are. It is not just to control the RP. It's not just to say that, yes, run the process like this. It is resolution at the end of the day, that this is what we are supposed to drive. And in the common interest of us all, we should be able to drive. I believe there is a proposal underway at the ministry to have some kind of an oversight over CoCs also. And I think it would help if this oversight means that, somebody can talk to all CoC members and say it is in everyone's interest to go together. So those are the things I would suggest. Anjuji?
Yeah. So I think very rightly put it by Abhilash sir. We only can talk, we only can mediate, we only can satisfy or give answers or clarifications to their queries. We only provide them enough information and support to take the decision, like telling them the whole legal aspect, whole financial aspect, whole the takeaways of the resolution plan. So we do that. So as Abhilasha said, we completely do it with one-on-one with all the CoC members. We try to make them understand, we try to make them even understand this thing, that the more delays will only, one, that deteriorate the value, and two, it is, of course, if you will talk about the NPV of the net value of what you will be getting, so that will also kind of diminish over time. So it's always the best resolution is the fastest resolution. Also, sometimes, means, of course, there are exceptions for anything and everything, but in general, if you talk about, definitely you get better resolution the soonest you get it. And as Sir said, like, yes, sometimes there are issues, and if they have, like, any of the financial creditor has any exclusive charge on any of the assets of the corporate debtor, so obviously their inclination is towards, like, in the resolution or in the liquidation where they are getting better value. And that is why many of the accounts go into the liquidation, because of the CoC members not approving our resolution plan, and they are not kind of seeing the big picture, or not considering the interest, or interest of all the stakeholders. So then, if CoC members only sometimes have any myopic view about the whole process, resolution professional literally can only do their job, but not can take decisions on behalf of the CoC. So whatever is in our powers, whatever is in our kind of procedural duties, we definitely do that. And rest, obviously, it's with the CoC members, like, what do they want to do with the company. Yeah.
Very nicely portrayed. Though this is the basically tact of the RP which comes into play. That
Yes.
how he tactfully handles the different CoC members, meeting each of them, getting their perspective, and Abhilash has told कि मतलब एक बार उनसे offline पहले बात कर लो, stop करके उनका एक mindset पहले clear कर दो, and then open the voting lines and make sure they voting तुरंत के तुरंत.
Yeah. So in my team, there is a very funny way of how we say. So we have kept a secret word for this. Like, it is the BTS. So my team will always ask, "Ma'am, have you done the BTS with the CoC members?" So BTS is like behind the scene, in the sense, like, have you done individually talked about? So it's always like so this is a kind of laughing thing in our team, that we always talk about, like, yeah, we need to do the BTS with the CoC members. So that's how we do it. Yes.
I think a BTS is essential.
Essential. Yeah.
Because it's not just a CoC member. You have to get that FC's perspective, which means you have to go and meet the decision makers.
Yeah.
And again, I'm not taking anything away, but you will not get the thinking of the FC from the person there. That representative will take in what has been done, go back, discuss it, and then they will evolve their own opinion.
Yes.
Right? But yes, you're right. I think what we need to do is to develop that kind of thinking on the feet to take it. I personally use several other things. I try to find out who is the leading bank there, the lead bank. Try and get them to start influencing other people as well. The fence sitters. But the whole thing is, that mutual trust has to come out. That yes, we are not doing it, only for their interest, or it is in their interest. I'm sorry, I'll take another minute. There was another case I said where we had to sell an asset, and there were two groups of FCs. Okay, and the asset we were selling was a security of one group. So effectively, after that asset sale, the second group would become unsecured creditors, right? And we actually had to call several what we call lenders meetings. We can't call them CoCs. We actually had to call several lenders meetings, sit down, and actually have a quasi agreement. I mean, obviously, it was not stamped or any such thing. That yes, everything would continue pari passu. Otherwise, what happens is, anyway, we have seen enough fights between secured and unsecured creditors. But the important thing is to just, again, try and get them to see reason that given that IBC does not differentiate between secured, unsecured creditors, let's not fight there. Let's come here. But to be fair to lenders, I mean, back of the mind, I'm sure they always carry what happens if the resolution process fails. we'll have nothing left but a security to fall upon, in which case we would be guilty of having given it away. But this is where you succeed or fail.
This is very nice idea. Matlab, to play with the scene during CRP only we can play with this secured and unsecured. So, like you come up upon rightly, the persons who is attending the CoC meetings, they are not, they does not have that much of power or the authority to take decisions on site. And there was a circular also of the IBBI which states that only the authorized persons who has the power to make decisions should attend the meeting.
Yes.
So, what is your intake on that view?
Okay, first, let us be fair to the lenders. In most cases, grade 6, 7, even 5, 6, 7 accounts are usually taken away from a single person and given to a committee. Okay, and the decision maker is somebody who's extremely high up. Given the number of CoC meetings, especially now that all RPs are trying to do them monthly after that last guidance, I really don't see GMs being able to attend all the CoCs that are possible. Just coordinating calendars is a mess, right? I think over here, what is needed perhaps is to make it possible, some kind of an enablement at the lenders to say the committee is able to provide some sort of authority to whoever the attendee is within whatever the limits they specify, and say, yes, try to prove upon that. The second thing also, and again, this is my experience, uh, usually at the lending stage, most lenders do have sector specific teams. Large banks would have, okay, this is the infrastructure team, this is the steel team, this is the energy team, etc., who at the time of lending, their expertise comes into a fair amount of use, because they use that to figure out the comparative advantage that their borrower has. Unfortunately, once an account turns non-performing, it is moved to the stressed assets department, right? And therefore, the advantage of that kind of sectoral knowledge, that kind of knowledge about this company, about everything, is usually missed out. So, if it were somehow possible to have that tremendous amount of knowledge available at the CoC level, I think we might see a more focused push on decisions. Anjuji, is that your experience?
Yeah, sure. So, I completely get actually their issues. So whenever so before, in fact, actually I became insolvency professional, I had no knowledge of banking and how it happens, and the hierarchy and the decision making, how it happens, and specifically like in the PSUs. Because private banks are more open to kind of delegate or decentralize the powers, but in PSUs it's very difficult. The structure is very different. And as Abhilashji sir said, like I think other than SBI, which was also in the initial years, like they had in the insolvency or stressed management group also like had their different teams for different type of sectors. Specializing the stress assets of that particular sector, but now they have also squeezed as the number of insolvencies have really reduced, so they have now again made it a one large team, I think. But other than that, no bank was having till now like any sector specific stress assets team. So definitely they don't have, but yes, it is very rightly said. And although now, after the experience of the banking, I definitely do understand that it is not easy for on their part to take any decision, because again they are saving their skins at many times. And what happens in banking, so it is a major problem that nobody is there on their seat for more than 1.5 to 2 years. And sometimes, CIRP actually stretches, obviously in 2 years or 3 years, and there is possible, like there are 2 3 people who have changed during the whole process of CIRP. And anybody who's coming new and getting into a history of a case, it's very difficult for them to take a decision very fast and things like that. And definitely they do not want to take any decision where there have been certain decision already been taken. And if they still have, say for example, it is possible that they have a different view on anything, but they cannot obviously change any past decisions and things like that. So definitely the decision making becomes very difficult among us themselves. And so much so that sometimes now the votings are happening for 5 5 6 6 years. In fact, in one of my cases, it's been on for more than 6 months now. I should not be saying that, but it's a difficult, because the thing is like, they have to have some approvals of the committees. Committees have been formed, and then something happened. Somebody retired. There a new member is coming, and all sorts of. So in this case, I have seen everything which happens in the banks. In taking any particular decision, and especially if it is an NRRA decision, like because there is not much asset and they have to kind of take up huge haircut, and nobody wants to take that responsibility in their name. So they don't want to sign on an NRRA, basically any officer, and they're just waiting. If they are getting retired in next 3 months or something, they are just sitting on it. They're sitting on it and they're not signing it. That whether I asked her, you can say no or abstain, do whatever, but let me conclude the voting. But they won't do anything. So these are practical challenges. We understand that even bankers have, it's not all that black and white or easy for them as well. So we obviously try and accommodate as much as possible. We try and understand their problems, and what in my control is that I keep talking and I keep calling that one person who's the manager of this case in the bank, and I just keep kind of pushing him. And after 2 3 calls, he will not attend my call for the next 1 week, and then again he will come back and kind of answer my call. So this happens. uh, Now the possible solution is, it's very important, that yes, the duties and responsibilities are clearly defined. They have their circulars. I'm sure bankers have, like for anything and everything. Without circulars, they don't do anything. They are circular driven anyways. But more specific maybe, or more descriptive, if their circulars can be. And as sir also said, that the powers are decentralized to a certain limit. Say for example, if there is an amount limit, if there is a decision limit, so those kind of, then maybe it can be fast tracked. But I think as long as in India we are doing banking in the PSUs, and they are public sector undertakings, and decisions is centralized, and nobody wants to take the responsibility of a wrong decision, then I think this is going to remain for some time.
So, like, I have a question here. Like, matlab, you say this voting is being deferred for months and years.
Yes.
Then, so with this, the CIP expenses also gets increased day by day.
Of course.
Yes, and then this delays the process. So
Yes.
now, at the when the question of answering to IBBI comes,
Hmm.
the RP has to is held responsible. Now, how you matlab, at that moment of time, will he say, no, I was waiting just for the CoC and he is not, matlab, will this be arguments be, listened before
Yeah.
IBBI?
Yeah, listen. So we definitely, because see, that is what I always,
So that time the IBBI can also say that why haven't you informed earlier to adjudicate that the CoC is not, cooperating with you to take forward the cases.
So IBBI is not getting into the procedural things. So we have tried multiple times, unless of course there is something which they are planning, any amendment or anything. But you please understand that even IBBI, if the courts cannot kind of compel CoC members, what powers IBBI has anyways? So they cannot compel any CoC member to act on certain things. or in a certain manner. So they can only, kind of give guidance or bring out the code of conduct for the CoC members, which they have done. But that is not, I would say, helping much, because the ultimately decision is of the banks. Or say, for example, financial creditors. So you cannot, kind of force anybody to make a decision.
Because this will go
Yeah.
on to matlab estimated CIP expenses will
So
take a turn. Everything will go on, and then matlab again then the question will
Yeah,
come, why
pick
this
up.
estimate and why this matlab the
Yeah.
actual expenses have been there. And
So-
anytime if you just rewrite कि no COC delay, तो मतलब it looks very मतलब
But what can I do?
yes,
Because
Abhilash sir.
day I am sending them reminder for voting every day, and I have in multiple times they have told, see, listen, and I actually, even showed them the mirror that it is your, cost which has been increasing. You will not get anything, and you will still have to pay so much for the liquidation cost. But still, if they are not understanding what an RP can do, you tell me. So we are, and simultaneously, I have actually informed the IBBI and the courts that this has been happening. I have
Yes.
even told them that if the court tomorrow, kind of puts a penalty on you, please be prepared. What? So I have, told them all the circumstances and the eventualities of not.
This needs to be monetized in a very proper way,
I
and
have
matlab,
monetized. I am doing every day email writing to them every day. I kind of so I have not extended the voting just in months or 15 days. Every single day I'm doing it. So
Yeah,
that I have documents
right.
of everything. Kind of give the proofs that I have been doing in my powers whatever I could. Yeah.
But Arjuji is absolutely right. See, in situations like this, what the RP needs to do is to protect himself or herself first from any kind of regulatory impact. And the way to do it is to just put it down on paper that, yes, I am trying to do my duty.
Yeah.
I have done my best. I'm not able to do because of whatever. Right. And she's absolutely right. I mean, we get questioned by regulators only when we find that the CIRP is running over time, etc. Please explain why this wasn't done, this wasn't done. And if you have the written proof, that is taken care of. The second thing, yes, you cannot really force a bank to say yes or no or within this specific period of time. Certainly not the IBBI, who's not a regulator for the banks. And even, as she rightly said, even the adjudicating authority would not get into it. I think, however, that there is one area which powers need to look at. I think the operating procedures in the banks still predate the IBC. They were made to handle whatever was the insolvency uh, process at that time, right? Now that the IBC is here, I think if a high-level discussion were to happen between the banking regulator and the insolvency regulator, right, and to say how the operating procedures within the banks can be modified if an account has moved under the IBC, because only if the banking system supports IBC and vice versa will we realize the greater value of IBC. And I'm sure this is something that the RBI understands very well. I don't think there is any point in going to individual banks and saying, no, please delegate authority to whoever is attending. Please allow him to vote. It's not going to work like that. I think the whole system, because of clearly there was a different thinking behind how and why this system was evolved. Why do things go to a committee? Why is it a committee decision? Because there are several other issues within the bank that are formed. So I think if the banking regulator were to work out and say that, yes, for cases that have moved to the IBC, maybe you can follow this to ensure a faster turnaround and a better result.
Yeah.
Correct.
Just add on that, not the only banking institutions, but any regulated body, because as I said, that ARCs, NBFCs, private banks, all those who are, regulated
Yeah.
under banking regulations should be, ring fenced into this particular thing. And they should have come out, something like that. You cannot stretch a voting for more than, say, for example, 1 month
Yes.
or just a quarter
Exactly.
sometimes, because the committees have maybe sometimes quarterly meetings and things like that. So not, I think quarter is just more than enough. If so, you imagine if you are working in an organization, if you're doing anything, and if you're not able to take a decision for a quarter even itself, how would you run that organization anyways? So generally a quarter should be more than enough for any decision. So
It,
some regulation, something like that from
it
RBI or
happens. I had to wait 3 months for a resolution
yeah,
because we missed the date for submitting the resolution plan for approval by an internal committee by
yeah,
1 day. And they said, now, sir, this will be only taken up in the next committee meeting. I said, when is that? Sir, 3 months.
next quarter. Yeah.
Right?
So
So,
quarter should be
these are the
maximum.
things, these are
Yeah.
the procedural things that perhaps we can look at, and this would obviously need to come from the banking side.
Now,
Yeah.
have you come across any stage, matlab, when a CD corporate debtor is a going concern? And going concern expenses are something which needs to be ratified by CoC, if I'm not wrong. So if those expenses are not, approved by the CoC, they delay in that, then how will the concern runs?
May I start on this?
I think both of us are waiting to pounce. Given that only 1 hour is left, I don't know if that is sufficient for
Yeah. So
to handle.
actually,
Please.
initially the only the CIP cost, which are the process cost, were approved from the CoC members, and for the corporate debtor running cost, we used to give all the data to them. We will present like in every meeting, like whatever we have spent, whatever the revenue has been there, and whatever is in the banks and everything. So we used to definitely, for the transparency sake, we used to always present like in every meeting, if there are this is a corporator which is actually running. But after this regulation last year, like then when you have to get the approved of the corporate debtor running costs as well, and believe me that initially, obviously, you will only give an estimated amount for the approval. And if there is a minimal, a deviation from that estimated amount, CoC comes very heavy on you as RB. But you can imagine if a company, say for example, right now in our one of our cases, the running expenses runs into 45 to 50 lakhs per month. And in that kind of amount, leave alone the hundreds or the thousands, even lakhs, 2 3 lakhs up and down is very much possible, depending on what kind of expenditures you are doing, and what purposes you are doing the expenditures. And it can be on either side, like low or high. And if you, and the best part is, high is still you understand, if the CoC is getting, kind of little agitated, they get agitated on the lows also. So much so it is really, so jokes apart, it's very big problem with the RPs, because they actually should have the commercial wisdom, but they don't have. Please be practical, because they are bankers, they do not understand how businesses run. And most of, as we have talked about, that most of the people who are coming in the CoC meetings do not have that aptitude to understand the going concern or the running expenses of the company, and they only come back and bounce back. And especially the bigger institutions and who have bigger stake in the CoC, they do not make much noise. But anybody, any small financial creditor who is 1% or 2% shareholder of the whole CoC constitution, and they make your life actually miserable, asking such stupid questions, and expecting, I would say, not only just information, sometimes irrelevant and unnecessary information, and it makes really difficult. So I think this should have definitely be dropped, because this really making all the RP's life very, very
No,
hard.
I
Yeah.
concur 100%. I
Yeah.
think this approval of going concern caused by is, I think, a little bit of a regulatory overreach. Because for one, you can put 5 RPs here, ask them to define going concern costs. They will not be able to, because they're different for every different company. I mean, I am running a hospital under CIRP. I mean, how do I know how many medicines will be used, what kind of machine time would be used, how many doctors, specialists, what would be used? I have absolutely no way of predicting. And I completely sympathize with Anjuji. You know, we actually had a case where I had projected a cost of 100. Okay. And the actuals came out to 90. And there was this one small financial creditor, he kept fighting with me. Their problem was that they had taken approval for 100 internal. Now they have to justify 90 also internally. And he was extremely unhappy that you are making me write and go and justify, and boss will ask, and I don't know. Because clearly nobody goes into the depth of operating costs. That's not all. Next month, I had projected 100, I did 105 expenses. I sought approval for extra 5. They refused, saying we gave you approval for extra 10 from last month. Take the approval from there. Please. And frankly, it doesn't serve any purpose.
Any purpose. Yes.
It doesn't serve any purpose. Because at the end of the day, you are looking at the EBITDA. For a company in the CIRP, you are only looking at EBITDA. In fact, I am happiest if corporate debtor has a positive EBITDA, because at least CIRP expenses will come out of that. But otherwise, going back to lenders and seeking money from them for running CIRP is a big no-no. I'm sorry, it's a slight digression here, but if you ask me, I personally feel that we should have a regulation that says that in the first CoC meeting, first or second CoC meeting, the CoC should take a look at, I'm sure they're aware of the financial condition of the CD. They should take a look at it and decide whether to keep it as a going concern during CIRP or to shut it down. If they agree that it should be kept as a going concern, it should be made compulsory that they pay for the CIRP expenses of that period. Today, unfortunately, what happens is the CoC says, no, please keep it as a going concern. Obviously, valuation, jobs, etc., everything. And when the RP says, look, I don't have money, I have actually been told it is the responsibility of the RP to keep it as a going concern. It is not a responsibility of the CoC.
Yeah. So very true. Like we
So
sometimes
pathetic situation for the RP, matlab from without money. What
Yes.
matlab, just imagine how matlab he is going to run the concern.
And that is where, and interim finance on paper
It's
is
very
very
difficult.
nice.
It's very
But
difficult.
even after 5 years, we don't really have interim finance providers.
no.
I remember 4 years back, I ran around practically all over the country. I finally got a funding provider from Hong Kong. And then, of course, we had to go through that entire route. Is it going to be foreign direct borrowing? Is it going to be debentures? How do we structure it? What do we do? And the last minute, it got stuck because the CoC says, how can they charge 20% when we are lending at 14%?
Give money at 14%.
So he said, because he's ready to give money and you are not ready to give money. No, it will never be approved. So, it is these kind of things. So I think, from what the external funding provider told me, who is in the best position to understand the affairs of the corporate debtor? The existing FCs. Who is in a position to benefit first once the resolution happens? The existing FCs. In fact, who controls the CIRP from a commercial perspective? The existing FCs. So he says, why are you running around outside? The best people to provide interim funding are existing FCs. Why don't you ask them? So at that time, I came to know that normally what happens in banking is that once a account goes into NPA status, any increase in exposure requires, pretty high approval. and so high that it's almost impossible to get. So this is another thing which perhaps can be incorporated in that note that we were talking about earlier, that if a corporate debtor has gone into CIRP, maybe it might make sense to look at increasing the exposure, knowing fully well that that exposure, that additional exposure will have priority of repayment.
So they don't, it's okay if they provide, but the problem is they don't themselves, the existing FCs, they don't provide themselves and they don't allow you to take it from the outside.
Exactly.
And we are
Exactly.
basically, kind of funding without any interest, without any our own, vested interest. We are funding the CIRPs basically, not getting the fees. And the worst part, if I say like rest, let alone be the interest or anything like that, our fees reduces, our team's salaries increases, and we are funding that everything on our own pockets. That's the intensity of of these this aspect of we not getting any interim finance and not getting the CRP cost.
So that is point three of that agreement between the regulators. I think point three should be,
Yeah.
let the RP in the first meeting give an estimate of what CIRP expenses are likely to be,
Yeah.
which is fine. You can say there are CIR, the RP fees, the support team fees, the valuation, legal, etc., etc., etc. Let the CoC approve it, and along with approval
Hmm.
comes an agreement to fund it on a pro rata basis
Yeah.
and fund it in advance. I'll give you another example. We RPs have a very large number of deadlines. Okay, the public announcement must go by day so and so. The valuer must be appointed by so and so date. Etc., etc. All these things to be done. Where does he get the funds? Because getting funds is a two-stage process. First, you have to get the expense approved, and then you have to get the expense out.
And
Right?
then many times the lawyer fees, the litigation fees which are running, the lawyers are
Exactly.
not going to attend attend the second hearing if you don't give them the
Exactly.
fees.
Exactly.
Then what will happen?
Because the lawyers are not covered under IBC. The RP is. RP cannot say. So that is why I think, for the RP to be able to focus on the CIRP, what he or she needs is the support of the CoC. Take away the financial worries, take away the commercial decision making worries, right? And therefore, you can focus a lot more on the operating parts.
Then with this, IPE also can act as insolvency professionals. When they come into picture and IPE is appointed, they do not have to incur any support service charge. But when an individual insolvency professional in its capacity is appointed, we often see a support services requirement. Now, with this, what do you think? Because the IBBI fees is fixed, and they don't go beyond that. No CoC members, will give that. Now, when IP is ready to work on the same fees as an individual professional, as an IP, then don't you think, that's because without support services, an IP also needs support services.
Yeah, see, normally what happens is RP fees plus support team fee is normally equivalent to an IPE fee. Okay, the only difference is in nomenclature. Because, once we see the, how complicated or how straightforward a case is, we can work out that, yes, what is it that we are going to need. I, for example, had a case where we had 27,000 OCs. There is no way I'm going to be able to,
Manage this.
verify 27,000 claims. It's just not possible. And you know what kind of manpower you would need to be able to, collate and verify all these claims. I mean, the email traffic alone is enough. In fact, we had to open several Gmail accounts because no one would take that kind of, information load. So, so the fees are something that are there. But over here, rather than dividing it, I think one thing I wish COCs would do is to try and look at the complexity of the case without getting into L1 mentality.
Yes.
Today, unfortunately, what I see is L1 everywhere, which gives rise to a whole host of problems. When I took it up with FCs, I was informed that this is to do with, the internal guidelines that you should go by lowest price. But all of this disappears when we are hiring counsels for the hearings. I have had cases where, I say, okay, I'm taking, let's say, a B category counsel. No, 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 no. Why are you taking him? Take the other person. I said, look, this gentleman is available at 10 lakhs a hearing. The gentleman you are talking about charges 25 lakhs a hearing. We'll be saving 15 lakhs a hearing itself. No, 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 but we should go with a top quality counsel. I said, well, what about appointment of RP? No, 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 whatever is the basic of the IBBI scale, RP will be paid. So I think now that, some time has passed and it has given the professionals in resolution space some time to, cement their reputations, and there is a body of work behind them, how they have handled, how they have behaved. And I think it is time that we start getting out of this L1 mentality and move more towards, um, what do we say? And for competence, results are in nobody's hands, but then nor are the legal cases. So, sorry, Anjuji, you were saying something?
Yeah, so I was just saying, like, this is a misconception actually among us, the financial creditors, that if you are appointing the IPE as RP, then the support services are not required, and you do in that minimum fees. So whether it is a person who's an RP or whether it is an IPE, the process is the same, the work is the same, the team requirement or the human requirement is the same. So it is just that is a paper entity, but a person who's signing on behalf of that IPE would be running the same process, so the cost is going to be the same. So whether
Exactly.
it's in the RP or IPE name, if see, all depends on the complexity of the corporate debtor, if it is sufficient for the only RP fees. So whether it is IPE appointed or a human being appointed, like as RP, uh, then that fees is okay. But if the RP is appointed in a bigger case and the IPs, so how that even make any sense not giving the support services? Because it's just about, again, as Abhilasha said, it's the nomenclature, like whether the IPE or RP, the work is going to be the same, and humans only will going to do that, right? The team would be required to execute.
Hello. I think
Anjuji?
Anjuji's her video has freezed. There must be some connection problem. So we can move ahead with the questions. And a lot one questions have arrived.
Please.
Like the first question is, when
Oh, Anjuji is
faced,
back. Anjuji is back.
Anjuji, yes, Anjuji, you were saying
Anjuji, we
something.
lost you. Sorry.
Okay. So I was just saying, like, whether it is RP or IPE appointed, the work is going to be same, and the fee should be or depending on the complexity of the case, not on like who has been appointed to run the process, because the process is going to remain the same. Yeah.
Very true. I agree to the same, and I think there is some change in the mentality of the FCs.
Yeah.
And now we have received the questions. I'll take them one by one. So first is, commercial wisdom should not become commercial dominance. Should there be regulatory limits on the CoC's powers under the IBC? And how can IPs practically respond when CoC's decisions undermine the code's objectives? Abhilash sir, your take.
Okay. See, 2, 3 things here. First of all, I think there is sufficient control over CoC members internally, both in their own organization as well as with their regulator. Secondly, the limit to which a financial creditor can go is obviously the amount due to them. In fact, thanks to the moratorium, they are actually losing out on the interest also, right? 6 month, 12 month, 2 years, or 5 or 6 years also in some cases. So I think from a lender perspective, I think there is enough regulation there. I think it might be better to look at how they can execute and their duties and contribute to the CIRP better. I'm sorry, what was the second part of the question?
How can IPs practically respond when CoC undermines the code's objectives?
Okay, there are two aspects here: the code objectives and the
The
regulation.
commercial regulations, yes.
The compulsory regulations, obviously, there is no question. RP has no choice but to follow. I mean, even if it means standing up to the CoC, please, I tell all RPs, just do your duty as per the regulations. When we are talking of the code's objectives, and as Anjuji very rightly pointed out, there are going to be different pulls and pushes within the CoC members themselves. And all I can do is repeat what I said earlier, that you have a chat with them, try to explain to them, bring your BTS playbook into play, talk to all of them, explain to them how this is against the trend. I'll give you an example. We did have a case where the CoC was all set to approve a resolution plan where the FCs were getting a haircut of 10% and the OCs were getting a haircut of 60%. And FC's haircut 10%, that means they were getting 90% of their outstanding. OC haircut was 60%, they were getting 40%. Obviously, there were a few FC members who said, no, we have to maximize our take home, if I may call it that. We have to maximize that. And they were all set to approve. And believe me, I had to delay voting upon the resolution plan. I had a chat with all of them together. I said, it does not say anywhere specifically that haircuts have to be the same. No regulation says that. However, you do have a fiduciary responsibility to look after interests of all members. Please don't go down that path. You will be inviting questions from the adjudicating authority. It took some time. Some people were not happy, but thankfully they all saw reason and they agreed to it. And as I mentioned earlier, in addition to 100% approval by CoC, whenever judges see that the amount of haircut, there is absolutely nothing, interests of all OCs, employees have been looked after, they don't ask questions on that. So I think it is important for the RP to talk to all CoC members, explain to them what the objectives are and why you are saying what it is. In the end, obviously it's their right to vote yes or no, but I think the RPs must make an effort. Anjuji?
Yes, Anjuji.
Yeah, so I think definitely the first part, commercial wisdom should not become commercial dominance. I would say yes, a big yes, because anyways, my take on this is that CoC has all the rights anyway. They can ask for any information from the RP whenever they require. And even before this regulation was existing, we were doing in every processes of ours a monthly kind of presentation to the CoC about all the expenses, about whatever is happening in the, so any right in the best practices, any RP would anyways be doing that, and they always have all the rights to collect any information, ask any questions to the RPs. So what is the point of creating, and sometimes, please trust me, not only us, it's CoC members also, they don't want to do it. The people who are sitting in the CoC, or people who are there in the in their offices, and have been given this extra burden of approving the costs and all those stuff, they also don't want to do it because they know that they cannot do it actually. So it is both ways. We can always facilitate them. If they want any information, we can always provide them. So that is something they can always do. So rather than putting all this into regulations and doing this type of stuff, I think like IBB, I should think about it or doing away with this and
Like, I think I'll like to interrupt in this question. I think, matlab, like appointment of professionals, when there is a need to appoint a transaction auditor or forensic auditor, and when RP sees and he believes that no, some more periods needs to be incurred, and for that number of years, the cost should be highly approved. But then the CoC comes, no, cannot take that extra cost. So that is matlab, how then IP needs to deal with the matter, because he is like, appointment, same appointment of valuer, appointment of legal professional, or appointment of asset tracing agencies, like which we are now seeing at very much familiar. Then the CoC are not ready to approve those costs, and from as per the RP seeing the stake, he thinks that these expenses are required. Then what should be their take, matlab.
So this is the second part of the question only. So then we have to comply with certain things as the code and regulations, and we do that. So sometimes, yes, we need to be little, kind of what it is called, harsh to be, right or something like that. I'm just forgetting the kind of analogy used for that. But sometimes, like we have to become, determined to let the CoC know that this is something which is, say, for example, I'll give you one example. For the sometimes for the TRA audit transaction auditors, CoC comes and says that please appoint this one and appoint that one. I simply say no. Like, I am an independent person. I will, any professional who I'm appointing for the process has to be independent for meeting the objectives of the code. So anywhere there is a conflict in the objectives or the law, and if CoC members are kind of asking us to do something like that, we definitely say no. So then we have to make the decision, and we actually kind of sometimes, if it is possible, we monetize it somewhere or document it somewhere, if because later on we do not want to any regulator coming behind us also, so we need to do that. But in most of the cases, like if there is any conflict in the code and or the objectives of the code and the CoC's decisions, we definitely let them know and we take the decision, because then we kind of, I would say, a little hard word, veto, but obviously we do not just take the veto, but we try to make them understand, and they understand means eventually.
So, matlab,
So it's
RP needs to be, judge himself. He should
all
not
the
always
time.
be carried away by the CoC. And
Yes,
if it is required, he should
yes,
be saying that, no, this is
yes.
required as per the
It's
guidelines, and I'll be going with
absolutely,
this appointment, and you need to approve the same.
yes, absolutely. Saying sometimes no is as important.
Hmm.
See, I think over here, the RP is in a bit of a cleft state. Okay, if you look, and I think the regulations need to be amended to allow some flexibility to the RP. I think there was a very nice case here that you mentioned about a transaction auditor. If if you look at the regulations, I think it is perhaps the most highly regulated area, avoidance transactions, and there are reams upon reams of guidelines and regulations on how the RP should go about doing it. Unfortunately, it is only the RP's responsibility. So what you are bringing out, is it from a personal experience? Thing of not appointing a transaction auditor? If the CoC refuses to allow a transaction auditor to be appointed despite the RP's approval, I think there has to be a fallback for the RP, to say, look, I am sorry, I brought it up. It was cut down or vetoed by the CoC, and therefore I am not able to take it further. Right?
Yeah.
But the way regulations stand today, if the RP feels any time that there has been, any kind of such avoidance transaction, it is the RP's duty to follow through. So this is somewhat similar to, appointment of valuers also. I can go out, I can get, quotes from 3, 4, 5 auditors. I can make sure that conflict, relationship issues, etc., everything is taken care of. But at the end of the day, the approval for the cost needs to come from the CoC. So I think what we need to do here is probably give the RP some leeway or make it compulsory that if these conditions are met, the RP's decision will be accepted. Or if not accepted, RP will be exonerated from any kind of action against, for not doing his or her duty.
Yeah.
That should be monetized.
I think Anjuji has mentioned it several times. The best thing to do is to try to monetize everything.
Everything, right?
By the way, I have seen that all your correspondence on one side, when you are arguing it at the NCLT, the first thing judges ask for are the minutes of the meeting.
Yeah.
Please get the minutes of the meeting. And if your minutes are drafted properly,
Yeah.
and make sure you give a chance to the CoC members to, go through and adopt them formally in the next meeting. If your CoC minutes say something, it is taken as what would you call patthar ki lakir, right? And
Coming to the next question, when faced with conflicting directions from the CoC and the adjudicating authority, NCLT, whose directive should the IIP prioritize and why?
there's a no-brainer, a complete no-brainer. It has to.
Adjudicating authority.
You cannot, right? In fact, there have been several cases where I have had judges come back to me on commercial matters. And we have had, I can't stand up and tell the judge, I'm sorry, it's not your thing. But whatever has been passed has to be done by the judge.
Yeah. So, in fact, I will just add, it's not only no-brainer. Obviously, we will listen to or we will prioritize what NCLT is saying. And in fact, in some cases, this NCLT thing only helps us. Because if, I am fighting within the commercial wisdom of the CoC or different CoC members, I go to the NCLT only for directions, because that's the only way they will, kind of listen to me. So in fact, not only it's no-brainer, it's the only way we, kind of seek to and we resort to, actually. So if something is happening for a longer period and we have not been able to decide anything, so we have gone to NCLT in multiple cases for when the CoC is not able to take the decision. I do that. Yeah.
So that is quite crystal and clear that we have to follow the educating authority advice, and we have to stick by it.
Yes.
Can an IP be held liable for loss of value if they follow CoC instructions that later prove detrimental to the insolvency estate? What safeguards can the IP invoke? So they mean to say कि मतलब yes.
I think the current framework does not cast anything upon the RP as regards the value received. Right? I think they're pretty clear. The commercial wisdom also means a responsibility for the value of the outcome is solely upon CoC members, and for a reason. It's their money. They have to decide what is best. So I think the current framework, I don't think such an issue will ever come up. In fact, I have never seen a single case where an RP has been questioned for a lower resolution value for several reasons. First is that the RP is supposed to follow the process. If he is correct regulatorily and legally, I don't think any fingers can be raised on the RP. Secondly, see, the value of a CD is also a very vague thing. In my private equity days, we used to say that the beauty lies in the eye of the beholder. And different people will see different, the same CD in in different way, right? And I think the RP can do his best by carrying out the investment banking functions in a nice way. Try to get as many PRAs in as possible. Try to talk to them. Try to tell them how this could be a good thing. But at the end of the day, the RP cannot be held responsible for anything. If you remember the Videocon case, I think while the court asked questions on why the value was so low, I think there was more than a 95% haircut, if I remember. Absolutely nothing came to the RP. So I don't think the RP should be bothered about what the value is going to be. They should be more bothered about keeping to the timelines and to the regulatory requirements. Anjuji, what about your thoughts?
100% from the day one of IBC, I've been telling like no asset, because whatever valuation we get it done, whatever things we get it done,
Yeah.
unless the buyers, unless the investors see any value in the assets or the company, no matter what valuations a valuer has given, no matter like whatever the CoC members have done, you cannot sell it.
You
So
can.
it all depends on the inherited value of the company and the asset. And that again, 100% I've been using this nomenclature that the beauty lies in the eyes of the beholder. So the investors only will decide what value, you will, or the what price tag you will put on the company. So definitely RPs cannot be held responsible for. And this is what I, in fact, in almost whenever a plan is being discussed or plans are discussed in any of the CoC, I keep telling the CoC members that you need to, see, and you need to negotiate. Obviously, I will facilitate all the negotiations and everything, but with the RAs, and we at the same time, like we obviously tell RAs to, kind of increase value every time possible. But RPs cannot, they can only facilitate the whole process, and they can educate the CoC members on how, they can, in fact, increase the value of the assets and things like that. But RPs cannot be held at
Like
all,
in this
in
example,
fact.
can we understand it like this? Matlab, I'm just asking that suppose there was an avoidance transaction and the RP needs to file an application. For that, he needs to appoint a forensic auditor. Or some there was an arbitration matter, and then, or there's a debtor which is more than a crore, which RP wants to file a RP case. And the CoC, because of the expenses, he stops the RP. No, we won't be giving it, and the RP does not go for it. So can that be also created as loss of value, or there can some recovery must have happened from there. So
Yeah.
can we just discuss in this direction?
Yeah, so I think Abhilasha said it very clearly. The asset, the company belongs to FCs. And if they do not take any decision which can enhance the value of the asset or the company, it is their loss. And if they are not taking action for, kind of minimizing their losses, what an RP can do. See, it is something like आप घोड़े को पानी तक ले जा सकते हो, उसको पिला नहीं सकते जबरदस्ती. We can only tell them that do this, do that, or don't do this or don't do that. We can only tell them the do's and don'ts. But if still they are not doing, we as person or professionals cannot be held responsible for it. आप कुछ नहीं कर सकते. जैसे मैं बता रही हूँ, मैं अपने सारे CoC मेंबर को ये जो 6 months से मैं इस बैंक को बोल रही हूँ कि भाई आपकी कॉस्ट बढ़ रही है, मेरे को नहीं इसको चलाना है, आप इसको अप्रूव करो या जो भी करो, मैं रेजोल्यूशन फाइल करूं. मैं 6 महीने 7 महीने से पक गई हूं उन्हें बता के. पर अगर वो स्टिल वो नहीं डिसीजन ले रहे, मैं उनके बिहाफ पे डिसीजन नहीं ले सकती, मैं वोट नहीं कर सकती. तो वो करना तो उन्हीं को पड़ेगा. So, sir, yeah.
Yeah, I think that is very nice way to put it. There is RP cannot and should not get into any kind of partisanship, and please never ever say that this PRA is better than that PRA or whatever. No,
We
you
never do
just
that. Yes.
never ever do that. Just stay away. On the other issue of costs that you mentioned, do we appoint a transaction auditor? Do we not? Right? Yes, ultimately it is their money, it is their call. All the RP can do is to record it. Record it that yes, I brought it up, it was turned down, and therefore I am unable to proceed in the matter. But as I mentioned before, this is perhaps one gap in the regulations. It will help if it is filled. I mean, I don't know what is in the lawmaker's mind. Is this something that must be pursued, or is it something which is an option? I really don't know. If it must be pursued, then the onus should be taken away from the CoC. They cannot influence the RP not to do something.
Well taken, sir.
Right?
We'll
And
move
if it
forward.
is, and if it is, voluntary, or if there is a choice about it, then again leave it to the commercial wisdom of the CoC.
There's
I think
another question. It says, in a pre-pack insolvency process, how does the IP balance the CoC's commercial decisions with the need for procedural compliance, especially in fast-track timelines?
I think it doesn't matter whether it's a fast track process or pre-pack or whatever. RP timelines are sacrosanct, and I think our judiciary made it very clear that their timelines are directive, RP timelines are mandatory.
Very true. Matlab in that
So
CRP or fast track, if the cases are being
it
delayed.
doesn't matter where you are, right? So, and I know that the RP things are, there's only so much in his or her hands, as Anju ji has been pointing out about her voting condition. All she can do is to have a, kind of an audit trail ready and say, I have done my best. I have been after them. Please vote, please vote. But if they don't, at least she's covering herself by saying that, look, I tried my best, but meeting this particular timeline is not within my hands, right? The the next step logically would be, I'm sure she would need to go to the adjudicating authority to seek a 90-day extension.
I'm doing that.
And
Yes.
the reason for extension you will provide is?
I will do the same reason. Why would I do any other reason? Yeah.
Exactly.
Yes.
So she said a while back that sometimes, if there is a kind of a different way that the CoC is thinking, use it to your advantage in the AA, and that is what will happen.
So,
So
like
what
the next
happens?
set of question I'll ask Anjuji, if the CoC approves a resolution plan that offers less than liquidation value to operational creditors, can the IP still proceed with the plan? What legal risk arise from the IP in such a scenario?
So this has been covered actually in the law itself. And I understand that this question is not from the professional person, because the liquidation value due to the operational creditor is actually been safeguarded in the law itself. So when the RP is doing the legal compliance, the only thing RP has to be sure about that the RA or the PRA has given an undertaking to take this up, that if the operational creditor has any liquidation value due to him, that will be given in priority. So obviously the fallback of this taking would be on, in fact, the financial creditors. So there could be two scenarios where the RA may say that this will be over and above the plan or money he's been offering to the financial creditors, or he may say in the plan itself that whatever the liquidation money would be due to the financial creditors, that will be given from the share of the FCs, and the FCs payout would be reduced to that much amount. So that's the only thing which the RP has to look into it, because anyways, if the RA will not give this undertaking or affidavit that he will be providing for the value to the operators or dissenting financial for both a team, then the plan is not complete. RP will not or should not, in fact, put that plan to the voting. So it has been very much covered in the law only. RP does not have any, kind of say into this. It is otherwise
Very
any
nicely.
different view.
Agreed. So, Abhilash, sir, next question goes to you. Where the CoC proposes differential treatment of similarly placed creditors, what role does the IP play in evaluating whether such classification meets the test of fairness under IBC jurisprudence?
I think I partly covered this when I took my case where, the FCs were getting a higher haircut than, a lower haircut than OCs. I think it is the RP's duty to inform CoC members when something does not meet the objectives of the code, right? As I said, this is something which is not mentioned in the regulation specifically, but it doesn't stop the RP from mentioning and recording that, yes, they mention. At the end of the day, the RP cannot override any decision of the CoC over here unless it blatantly contravenes the law. But even then, if he records his or her objection and also how we try to it, the fact is it will be struck down at the court stage itself. And to be fair to CoCs, they are also extremely conscious of doing something which can be, where they can be hauled up for in the court. No CoC member will ever force a decision where there is a danger of any kind of should we say, adverse comment from a judge also. So I think, in short, what the RP needs to do is perhaps explain the relevant regulation or relevant objective that is being contravened by such a decision. And I think they will find support for what they are saying among CoC members.
Okay, next
So
question,
I
which
think I was
yes, Anjuji.
No, I just wanted to add, actually, similarly placed creditors. So I don't know what the question, the person who's asking the question means by the similarly placed creditors, because generally the code is very clear about that one class of creditor cannot be differentiated. So if he means by the same class of creditors, they cannot actually be differentiated. They cannot be given the different treatments actually. But sometimes RAs, bring in with some creative ideas, and they have their own description of different creditors per se, and they create class within the classes, classes within
Like
the
we all see now in government dues,
Yeah.
PF dues ko hum log they pay, and
exactly.
the other government dues they don't pay.
Exactly. So they will give some kind of clarification for their differentiation in the treatment. But if that treatment, say, for example, we can only tell them, RAs also or the CoC members also, that this is not right, say, for example. But that does not make a plan uncomplied or non-complied. Okay? So then we definitely file that plan to the NCLT for approval. But then NCLT sees it. So I can say it for sure because this is happening right now in one of my cases where this operational creditor is actually a land owning authority. Right, because of the reason that there are operational creditors, the RA has not provided enough funds for that, and court has actually asked to bring that creditor because it was a land authority, land owning authority, and the case is of a real estate. So the court itself observed that how you will kind of implement this plan if the authority will not give you the land, which is a secured operational creditor. So in that case, courts also take kind of very mindful things. So I have observed. So if the RA have created some ideas on differentiating the creditors, court will definitely seek views and will bring those creditors and the RA and everybody, and because you as RP cannot make them understand. CoC still is approving the plan. What can you do for the treatment? So then courts will take care of it. So I think that's not a problem, and courts have been very, very mindful about this.
Just to add a small thing, I think because the plan is presented by the PRA, I think it is incumbent upon the CoC, aided by the RP, to discuss this with the PRA.
Yes.
Discuss with the PRA and say, look, why are you giving a plan which, why, on paper it is compliant, but it doesn't really meet the objectives of the law, and it is sure to attract questions.
Yeah.
So another question we have is, do existing IBC regulations sufficiently empower IPs to challenge or reject directions from the CoC that may contravene the law? If not, what specific reforms would strengthen their position?
See, I think it's very clearly laid out that the RP has to abide by IBC and all the regulations. Okay. So there is, I don't think any further regulations are needed to tell.
And we discussed when we face such situations, we should say no, as Anjuji rightly said.
However, we were talking of tact and the ability to talk to people a while back. I think it is important for the RP to learn how to say no. That's very important. Don't forget, your next project is going to come from the same financial creditor, right?
Yes.
True. So,
right. So in a sense, the RP is a CEO working under the directives of the board of directors, which is the CoC. You are telling the board of directors you are wrong, don't do it. So I think you have to learn how to tell them, look, I'm sorry. And frankly, as I said before, I've never seen a CoC member, insist on doing something which is against the law. It doesn't happen. So I don't think there is too much of a possibility. But like I said, being nice and polite about it will not hurt.
So I think from the day I became an RP, I realized the best skill set or the best talent RPs need is the interpersonal skills. How you communicate,
Absolutely.
like how positive impact you are creating by your communications and not, kind of agitating any of the stakeholders and still treading your waters or navigating the process in such a manner that you get the positive outcomes. I think that's the best skill we need as RPs, all of us. Yeah.
So
So that's
another question what we have is, from a governance and procedural standpoint, what is the ideal balance between CoC authority and IP autonomy to ensure a fair and effective resolution process under the IBC framework? Ideal balance between CoC and IP
Yeah,
autonomy.
I think, I'm sorry, Anjuji, may I take
yes.
first? I think we have discussed this. What is important is for both sides to understand their roles and responsibilities better and see how we can drive towards a thing. And yes, there are a few, one of things like we mentioned about the avoidance transactions, where if I have the responsibility, I shouldn't have to depend on somebody else's authority.
Mm.
That is, so I think there are just a few things, mainly to do with expenses, appointments, etc. If there are any, so in short, I would say if there are any mandatory duties to be done either by the RP or the CoC, the other side should not be able to influence or stop that. Anjuji, anything on this?
No, I think it's very well said. And the only thing, as long as the RPs are not doing anything, against the law or regulations, generally CoC does not, but sometimes, yeah, some CoC members for their own vested interest may, kind of force RP to do certain things. But then we need to be very, I would say, diplomatic and polite in handling things uh, that we both are for the same purpose. Basically, we are on the same side, basically. So that's what is very, very, but I think from the COC's point of view or from the stakeholders point of view, which is missing in the ecosystem is the trust they have in the RPs. I think that is very, very important, that the COC members uh, come with that, trust already built in the RP, and then only they empowers RP to gain or have the desired goals. So that is, I think, very important. And generally, like we, as I said, that we did not have much conflict with the COC members as of now. I think apart from just one of a case, but most of the time, like it's been very, very cordial relationship with COC. But yes, they just have to be little mindful of that, because they have the authority to appoint the RPs and things like that. They should not, kind of take away their autonomy to work, because ultimately it is for their favor, not for us.
And they should, the RP is also not governed, he is also governed and regulated.
Yeah. So for us, like there are 10 regulators sitting already. So I don't think like an RP can really stretch a lot their powers or their autonomy for their own purposes. I don't think so. That's happening. Yeah.
So another question what we have is, in what ways can CoC decisions potentially compromise the independence and accountability of IP during CIRP?
So I think the same thing Abhilash sir also said, and I also said, because in 80-90% of the cases, we are appointed by them. And they might have, they try to use that influence to their own benefits. So it's very difficult for us. So it's a very tight rope on which we are all the time, walking. Because if you do not, say, for example, if you do not make them happy, it's possible that you will not be getting the next case. So it's very difficult, becomes very difficult sometimes. But I think as long as your intentions are good, and you are working in the
As per
framework
yes,
of the
okay.
procedure or the law, I think things go right.
And it should be possible for the RP to convince
Yeah.
the CoC
Yeah.
member that what
Yeah.
he or she is doing is against the law.
Yeah.
That, frankly,
Then
nobody.
only it becomes detrimental. Yes. Yeah. So I don't think any RP will take that risk.
Hmm.
Yeah.
Yes, keeping the essence of time, we have, we have literally been discussing this impact on CoC and the challenges faced by the IP. And to sum it up, we have discussed on the commercial wisdom, the decision making, the voting lines, that the voting time that is taken by the CoC, the going concern expenses, that new regulations which needs to be ratified, which needs to be approved by the CoC, which is big, if the interim finance, and the fees of RP versus IP fees. And then we have just discussed that, if there is a challenge between a regulation and the CoC, we have to follow the adjudicating authority. We have to go abide by the regulations. The RP is bound by the IBC, and no matter what, he should not, he needs to stick to the compliances which has to be made to the IBBI and the regulatory bodies, and he should stick the law. And does not, there he cannot go wrong.
Yes.
So, any for today, because we are just up the time, it's 5 o'clock. Yes, ma'am. Ma'am, you're mute.
Thank you so much, ma'am, Anju ma'am and Abhilash sir, for this wonderful webinar. The role of CoC and the IP, both both are how can they make the ways to stick together without any conflict. So covering all the areas, and Rashmi ma'am also moderating the session with her own expertise and asking the questions in between the session. So thank you so much for Anju ma'am, Abhilash sir, and Rashmi ma'am for this wonderful, wonderful webinar. Thank you so much.
Thank you, ma'am.
Thank you all. It was a pleasure.
Thank you.
Thank you so
Thank
much.
Thank you, Abhilash ji, Anju ji, and all the, because we could only interact with each other. We could not see other members.
Yeah.
It was
would have been a
nice.
pleasure otherwise.
It was a very much pleasure. Thank you.
Thank you.
Thank you.
Thanks.
Thank
Looking
you.
forward to such
Thank you.
learning sessions more and more. Thank you.
For sure, ma'am. This is a beginning. I'm sure in this year we will schedule all these webinars.
Because
with
the
the,
monitoring committee, the MC, after the post approval of resolution plan, that monitoring committee chapter is also very much
Important.
needs to be discussed. So we can have a session on that also, because we did not cover in CoC this
Yeah.
monitoring committee thing.
Sure, ma'am. Sure. We will take
Thank
your
you.
this,
Thank
this
you. Thank you.
Thank you all.
Thank you.
suggestion,
Thank
ma'am.
you, everyone.
Thank you.